A powerful speech was given in support of lawsuits that challenge bans on AR-15s. David Thompson of the law firm of Cooper & Kirk, who is handling no fewer than 60 Second Amendment lawsuits, gave a powerful presentation explaining why it is unconstitutional under the Second Amendment to ban AR-15s. Here's his presentation to the Federalist Society over the weekend and to a bunch of federal judges, to intellectuals, to scholars, to lawyers, to law clerks, and many others. Check out the argument in favor of AR-15s and in support of the Second Amendment against gun control right here and right now.
Good morning. It's a pleasure to be here with all of you today and to share the stage with the titan of the federal judiciary, Judge Thapar. Bill Merkel is always very thoughtful, and thank you for an idea for a 61st case with challenging the Militia Act of 1803. I'll be looking at that this afternoon. And Mark Smith, whose videos are highly, highly informative. I always learn something when I listen to Mark. I agree fully with Mark's description of Bruin and Rahimi's methodology. You start with the text, then you look at the historical record, you derive a historical principle from the how and the why behind those analogs, and then the fourth step that Mark just identified, I think, is critical and has been missing from pretty much every decision that has messed up below, which is doing a cross-check for guardrails. If you touch a guardrail, you're dead. And if these lower federal judges were to assess their work against those metrics that Mark has just laid out, they would realize the errors of their ways. And I'm going to point out some of the errors of their ways this morning. And I'm going to start with AR-15s. And for those of you who aren't gun people, an AR-15 is a semi-automatic firearm. It is the most popular firearm in America. There are 44 million of them in the United States. They are lightweight. They are accurate. They have no recoil. They shoot bullets that are far less powerful than deer rifles, and they have far less of a blast range than a shotgun. So you might have thought, wow, that's great. Highly accurate, easy to use firearms. That hasn't been the reaction of many left-wing jurisdictions. There are a number of blue states that have rushed in a fit of virtue signaling to ban these. And they've also banned the standard capacity magazines that hold 30 bullets and that are owned. There are about 500 million of them in circulation in the United States today. So how are we to think about these laws? I'd like to start with a radical proposition. Let's look at binding Supreme Court precedent. And binding Supreme Court precedent from Heller teaches and provides a very straightforward test. Firearms that are commonly possessed by law-abiding citizens but for lawful purposes cannot be banned. Full stop, period. Let's go have lunch. It's that easy, okay? You don't have to do anything else. And so let's look at AR-15s and see, does that fall within the Heller test? Well, the first question, are they arms? Absolutely. Dr. Johnson, 1775, in his dictionaries, defined an arm as any weapon of offense or defense. So clearly these are arms, and these are arm bans. So then the question is, under the Heller test, are they commonly possessed? Well, we don't have to emanate in the penumbras. These are the most popular firearms in America. So if the test has any meaning whatsoever, it must cover the AR-15. Ditto for the hundreds of millions of magazines that are in circulation today. Are they owned for lawful purposes? Yes. Now, we don't have precise statistics, but if you assume that every firearms homicide committed in the United States of America with a long gun was an AR-15, and they're not, but if you were to assume that, you would conclude that 99.999% of these will never be used in any criminal activity whatsoever. And when we look at surveys and people are asked, why do you own them? They say for self-defense, they say for target shooting, and they say for hunting. And if you think that sounds really straightforward and that the lower courts would just follow this methodology, you would be wrong. Because almost every month we are treated to a new 100-plus page opinion from a court of appeals telling us why that, what I've just said, is wrong. So where have the lower courts gone astray? Well, some of them say and pretend that these firearms aren't actually arms because they're useful for military service. But that's wrong at every conceivable level. The U.S. military does not use AR-15s. They are semi-automatic. They do not provide suppressive fire. When you pull the trigger once, you get one bullet. And militaries want to have automatic fire capability. They want to have machine guns, and these are not machine guns. Let's look at the guardrails that Mark identified and see if this test in any way violates them. Is it consistent with the text of the Second Amendment? Absolutely not. Check out the prefatory clause, which emphasizes the importance of the militia. Is it consistent with a purpose? Absolutely not. Heller said you want to be able to repel foreign invaders. That requires military proficiency. Is this test consistent with precedent? No, it's not. Heller has a different. Is it consistent with the analogs that Heller identified? No, Heller said in deriving its test that you look at analogs where and you can only ban dangerous and unusual firearms. These are not unusual. Now, the D.C. Circuit has treated us to a different test. They have recently held that arms can be banned when they are capable of unprecedented lethality. Unprecedented lethality compared to the firearms that came before them. And that's wrong too for a number of reasons. Justice Scalia ridiculed as bordering on the frivolous the notion that the Second Amendment only protected arms that existed at the time of the founding. And indeed, the entire history of firearms is the relentless, continual search for more lethality and more accuracy, because these are instruments that determine your life or your death, whether you're going to live free or as a slave, or whether you're going to live as a citizen in your own country or a serf in somebody else's country. And so you bet your bottom dollar that everyone is constantly trying to make these arms more accurate and more lethal. And you say, well, okay, David, but the founders couldn't have envisioned something like an AR-15 that fires 20 bullets at a time. In 1775, someone came to the Continental Congress and said, let me demonstrate my new firearm that fires 20 bullets without reloading. And so not only could they have envisioned it, they actually saw it. Now, the principle of banning firearms with excessive fatality touches upon numerous of the third rails that Mark identified. It's foreclosed by precedent. It's inconsistent with the purpose of the Second Amendment, repelling foreign invaders. It's inconsistent with the how and the why of firearms regulations because they're commonly owned. And it's inconsistent with looking at the regulations from the perspective of law-abiding citizens, as opposed through the lens of how criminal might use. You can describe the exact same features as increasing accuracy and the ability to defend oneself, or as having excessive lethality in the hands of criminals. Those are two sides of the same coin. And what Heller teaches is we're going to examine firearms regulations from the perspective of law-abiding citizens, not how criminals are going to misuse them. As Mark indicated, the entire defense of the District of Columbia and Heller was, we're allowed to ban handguns because criminals love them. And Justice Scalia said, I don't care. That's irrelevant. They're criminals. They don't follow the law. What we're going to look at is whether law-abiding citizens have a legitimate need. How do we know that? We're going to trust and empower the American people. And if they, in large numbers, have gone out and acquired a firearm for their self-defense, then that's the end of the story. Now, there's a third test that we've been treated to, and that is whether the lower courts have said that Bruin said that they have to be commonly used for self-defense. And they said, so unless you can prove that these firearms are used commonly for self-defense, you lose. And there's nothing really inherently wrong with this test, but the flaw is that anti-gun advocates are trying to draw an artificial distinction between possession and use. When you buy an insurance policy, you're using it. When you're driving your car with your airbag, you're using it. And when you buy a gun and you keep it in your house for self-defense, you're using it all the time, even if you don't have to pull it out and shoot someone. How do we know that? Let's check the guardrails quickly. We know it from the text. It talks about keeping, not keeping only if you use. Let's look at, is it inconsistent with a purpose? Of course it is, because one of the purposes was to be able to have a firearm in case of an emergency. Is it inconsistent with precedent? Yes, Heller said nothing about this. And Bruin wasn't a rewrite of Heller, as Mark said. It was cited 100 times. Is it inconsistent with historic practice? Yes, it is. There's no indication at the time of the founding. The founders thought, oh, well, we can ban any gun that people aren't using frequently. So the bottom line, here's the bottom line. When you're dealing with a case with a gun ban, Heller governs, and you'll always be able to prove that with a cross-check against the guardrails that Mark has identified.
Orders up. Table 2A.